Good afternoon. I think we only have two cases on this afternoon's docket. We're going to start off with 30063, Vernon Smith versus School Board of Concordia Parish, the Delta Charter Group. So Mr. Hooks, you're batting leadoff today. Welcome.
Thank you, Your Honor. May it please the court. I'm John Hooks, and I'm honored to be here today on behalf of Delta Charter School. Our firm has been helping Delta comply with its obligations under federal law since spring of 2020. Your Honor, the first thing I did when I got involved in the case was go on an archaeological dig to figure out exactly what had happened in the more than 50-year-old case. As the court is well aware, this matter started in about 1965. There were desegregation orders that were put in place in the 1970s. And to this date, with very few and minor modifications, the student assignment plan has continued on in Concordia Parish, so that its schools now, of the 10 or so schools, only one, the magnet school, has a racial balancing requirement imposed on it. None of the other schools do, and about half of them are virtually one-race schools. There was no evidence that I could find of any desegregation activity on the part of Concordia Parish, and all attention instead had focused on Delta. But Delta, of course, was not the original wrongdoer in the case. I also looked at the demographic data of the Concordia Parish student assignment plan, and of the 10 schools, 5 were and are racially, virtually one-race schools. Delta, although merely an intervener and not a party to the case, had a very strict racial balancing order. Nothing in the record indicated the purpose, however, of that racial balancing order. There was no evidence the district court had ever held a hearing, first of all, to determine what, if any, desegregation obligations remained on the part of the parish schools, and had not linked the remedies ordered with respect to Delta to any present-day manifestation of past de jure segregation. There was no evidence of that, and to date, there is no evidence the court has ever conducted that inquiry.
Mr. Hooks, I confess I'm a little hung up on kind of some threshold procedural items. So the district court, they construed your motion to modify as a Rule 60B5 motion, correct?
Yes, sir.
And on appeal, we reviewed denials of those motions for abuse of discretion. Is that right?
On a Rule 60B motion, abuse of discretion, Your Honor, yes. But at the same time, it's important to note that even under that standard, this court reviews the conclusions of law the district court makes de novo.
So here's what's kind of gnawing at me a little bit. You don't seem to offer a heck of a lot of briefing or analysis regarding either Rule 60B or the abuse of discretion standard in your briefing before us. And unless I missed something, and correct me if I did, you seem to mention the former once in your opening brief, maybe in a footnote, and the latter not at all. And I'm not sure how you can effectively kind of tee up, how you can effectively frame your argument on appeal if you essentially kind of disregard the governing standard of review. Where am I off base? Am I missing something?
Your Honor, I think the most important aspect in answering the question is to recognize that we're here on a rather unusual circumstance in which we have an intervener who comes into a school desegregation case that wishes now to have the court review the constitutionality of some of the obligations imposed on the charter school. Historically, courts have reviewed interlocutory orders as such in this court without having them sift through the requirements of or clear the hurdles of 60B. Those injunctions that are ordinarily referenced in the Rule 60B context are, for example, in the context of SWIFT, they were final injunctions that were imposed against, in that instance, the meatpacking industry, and they were obligations that were anticipated to last almost indefinitely.
let me ask my question maybe differently, maybe more directly. You say the district court should have applied Rule 54C and not Rule 60B,
Yes, sir.
but you make that argument in a footnote, and I wonder, why isn't that argument forfeited? And why isn't that inadequate briefing, as we have found in a slew of other cases, that relegating an argument to a footnote isn't really sufficient to properly tee it up?
Your Honor, in pages 7, 8, and 9,
Okay.
and 10 of our reply brief, we take on the issue under
In your reply brief.
of the district court could have analyzed Delta's request for relief under 54B. And we talk about how Rule 60 applies only to final judgments. And when a party seeks reconsideration of an order adjudicating fewer than all claims among the parties, Rule 54B controls. We talk about also that under Rule 54B, the district court possesses the inherent power to reconsider, rescind, and modify an interlocutory order for any reason it deems sufficient.
And this is all from your reply brief, right?
Yes, sir. And then we talk about how desegregation cases are unique and their orders are sometimes hard to define. The 2018 order more closely resembles an interlocutory order than a final one. And indeed, the 2018 decree addresses only remedial obligations ostensibly growing out of Delta's failure to comply with the 2013 order. It does not address any relief toward the actual defendant, Concordia Prsh. So, Your Honor, in looking in terms of the sometimes, I think, confusing landscape of desegregation decrees, we also see in a variety of cases that the courts look at interlocutory orders from desegregation decrees and have exercised jurisdiction in that regard.
As the party that is seeking modification, you do agree, right? You have to show a significant change in either factual conditions or the law, right?
I don't know that I agree with that, Your Honor. I think under the application, for example, of RUFRO, if you look at what the court was dealing with there, RUFRO, and in the Swift case I was mentioning and others, you see, those are final judgments of litigation that had been going on for quite some time. So we're dealing with a final order in a consent decree.
So
we're not dealing with something that...
You might quibble with whether or not you have a burden to show a significant change either in factual conditions or the law. But did you, in fact, argue before the district court that either the facts or the law had changed? Did I miss something? It doesn't seem like you did.
Well, we've not argued. When asked, we were not of the position that the Harvard admissions case significantly changed the law in this regard, because we've been of the opinion that the race-based admissions program, as applied to Delta Charter School, was and has been, even under parents involved, unconstitutional. We have argued that consistently. We do believe the Harvard admissions case clarifies that and looks at the narrowly tailored prong with greater emphasis. But we do not contend that a change in facts or in law is necessary for the court to look at interlocutory orders in the context of a desegregation case. We know that this court in Lawrence County, the Fifth Circuit case, said that, in quoting from Swan versus Charlotte Mecklenburg, that courts may modify or amend interlocutory orders or desegregation orders as may be deemed necessary or desirable for the operation of the unitary system. We also refer the court to Valley versus the Rapides Parish School Board case, where the court there said that when reviewing a trial court's desegregation remedy, we are limited to ascertaining whether the court has abused its discretion. We are mindful that the scope of the district court's equitable power to remedy past wrongs is broad, for breadth and flexibility are inherent in equitable remedies, and significantly for our purposes today, although free to reassess the district court's conclusions of law, its findings of fact must be accepted unless they are clearly erroneous. When we look at the district court's opinion, we see that the district court required Delta to show a change in some kind of the facts or law in order to bring to his attention the constitutionality of the enrollment provisions contained in the admissions scheme that was set out in 2018. However, if we follow that mindset to its logical conclusion, then Delta would have to operate what could be, because the court has not examined it, an unconstitutional admission scheme indefinitely, or at some point until the parish perhaps moves for unitary status, and that's...
But why now? I understand you opened your argument with the fact that you entered this case in 2020. But if it was always the thinking of Delta, you take a case as you find it when you come in, correct? And so if it was Delta's position, if they voluntarily entered into this consent decree in 2018, what has changed between now and then, particularly in light of the fact that you're arguing the unconstitutionality of this order based on a 2007 case?
Your Honor, one of the most significant changes is that Delta has complied with these requirements for a reasonable period, beginning in the 2020 and 2021 school year. So we're in the fourth year of Delta's compliance with the admission scheme. Our best advice has been to Delta to comply with the letter and the law, every aspect of what has been imposed on it and what's agreed to by the district court. And in fact, it has done that. Even in the opinion in which the district court denied Delta's motion, the court was careful to point out that Delta had in fact been complying and in a sense congratulated Delta for its compliance. We do believe a change in fact could be the compliance, absolutely. We're of the opinion that as this court has held, a 3-year period of compliance is typically considered reasonable in a desegregation case or desegregation context for someone, for a district to be deemed unitary. And if we extrapolate that to Delta's compliance, then the 3-year period could in fact constitute a change in
One thing I kind of scratch my head over is you argue that the consent order or the consent decree is unconstitutional under parents involved. But as Judge Douglas mentioned, that's a case that the Supreme Court decided 11 years earlier. So you say the consent decree is unconstitutional under this case, but that case was decided 11 years before the consent decree was entered, jointly entered.
Yes, sir. Yes, sir. I appreciate the question, Your Honor, and I think it's important to point out that Delta entered into the case in 2011, 2012, and Delta at that time had been negotiating a way of entry that included a number of things that it was agreeing to along with consultation with the Department of Justice and with Concordia Prsh School Board. Delta came in over the objection of both. We also know another thing that was significant is that the school board announced that it was moving for unitary status in those initial pleadings. It said, we're about the business of moving for unitary status. Time and again, Delta relied on those representations that in fact the parish was moving toward unitary status when in fact 12 years later we find that it wasn't. And only after the prodding and insistence by the district court did Delta produce an exit strategy briefing, and that exit strategy briefing said unequivocally that it was the position of Concordia Prsh School Board that it had no remaining desegregation obligations. That's another change in fact, that there was no desegregation obligation remaining on the part of the school board according to the school board. So at that point in time, there is no remedy that can be said to correspond to a constitutional violation that exists even in the opinion of the school board.
One more question before your time expires, and we'll have you back on rebuttal. But one more minute. You've got familiarity with Horn v. Flores, right? Supreme Court case from 2009. So it was a Supreme Court case, 2009, Horn v. Flores. It was 5-4, but still controlling, still governing precedent. It was about Rule 60b-5. And I'm just going to read one of the passages from the holding. Rule 60b-5 may not be used to challenge the legal conclusions on which a prior judgment or order rests. 60B5 may not be used to challenge the legal conclusions on which a prior judgment or order rests. What are we to do with that statement from the Supreme Court?
Your Honor, the school district the charter school here, Delta, did not move for the court to consider it under 60B5. The charter school brought this to the attention of the district court primarily on the constitutional grounds, saying we believe now that we have a race-based admissions program that has evolved over a period of time into being something that, as time has gone by, has revealed itself to look much more like the admissions schemes that were invalidated by the Supreme Court and parents involved, and now in the Harvard admissions case.
But then your response kind of circles us back to what I asked earlier. You say the district court should have applied 54C and not 60B, and the question then, at least for me, is whether that argument was adequately teed up and briefed. But we'll hear you back on rebuttal. Mr. Blanchard, we're going to split time with Mr. Lee for the United States, right?
Yes, Your Honor, for 10 minutes for myself and 10 minutes for Mr. Lee.
Take it away.
Thank you, Your Honors, and may it please the Court. My name is John Blanchard on behalf of Concordia Prsh School Board, and we're here to respectfully ask this Court to affirm the District Court's order below. As was just discussed with my friend, Mr. Hooks, waiver is present in this case. At no point in Delta's brief did they argue that the District
Is
Court...
that equivalent to forfeiture?
Pardon me, Your Honor?
Is waiver equivalent to forfeiture?
Is waiver equivalent to
Yes, Your Honor. I think here that it could be. I mean, Delta, as Your Honor mentioned, they only mentioned it once in their principal brief, and that was actually in the procedural history section. They didn't actually discuss the substance of Rule 60B in any way. There was no change in factual circumstances argued to the district court. I know Mr. Hooks mentioned that Delta has considerations that they're in compliance now, but that was never raised to the district court. The sole question really in front of the district court was whether or not the race-based admissions criteria for Delta Charter School's kindergarten class was constitutional. Bringing us to the second prong of Rule 60B, whether there are any significant changes of legal circumstances, and with respect to my friend Mr. Hooks, there are not. Parents involved, as was mentioned here, was decided over a decade before the 2018 consent order that set forth the admissions criteria. Most notably, the parents involved case was not an active desegregation case. Rather, there were two districts in there. One was in a post-unitary posture, and the other had never been in a deseg case before, but the Supreme Court made clear that in that posture, you cannot have race-based considerations absent meeting strict scrutiny. But in ongoing desegregation cases, race-based admissions processes are commonplace. That was approved by this circuit in Davis versus East Baton Rouge in 1983 that recognized, for example, that magnet schools can't serve as a haven for one race, so having a race-based admissions criteria is allowed in our cases like these. Our district, Concordia Prsh, has its own magnet school, the Concordia Prsh Academy for Math, Science, and Technology, that does enroll students on a 50-50 basis, and there are a number of other.
What is the correct procedural path that a public charter school should take if they believe that race-based admissions collide, run afoul, clash, cannot be reconciled with modern Supreme Court holdings regarding the consideration of race?
Well, I think Rule 60b-5 would be a way to do that, Your Honor. I mean, that's the whole point of showing a significant change in legal circumstances. But parents involved was not a change in the law, and also Students for Fair Admissions v. Harvard is not a change in the law either. That case was strictly about higher education at Harvard and UNC, and the admissions policies that they used for their university admissions. But the Supreme Court there explicitly acknowledged that one of the two exceptions that they have found in strict scrutiny is desegregation. They cited two parents involved and acknowledged that these are the types of cases that meet that high threshold. And until the case is resolved one way, until it's resolved, district courts can impose race-based admissions criteria. And the proper way to have done that would have been to challenge the law under Rule 60b-5, and respectfully, Delta did not do that below. And I'll say this as well, our law firm represents numerous school districts across the state of Louisiana in desegregation cases, and to be honest with your honors, I'd be very happy if this court were to find that race-based admissions in desegregation cases are unconstitutional. That would end a lot in many of our cases, but until the Supreme Court says that, we don't believe that this court can hold that they are unconstitutional. They've been found unconstitutional for decades now. Again, our districts would be happy, but the way that the case law is now and the way the Supreme Court precedent is now, it's unfortunate, our client would say it's unfortunate that we do still have race-based admissions criteria in our desegregation cases. I do want to respond to one thing that my friend Mr. Hook said, to start out about how, Delta was not the original violator, and that's true. I mean, Delta didn't exist in the state of Louisiana until the district court approved it under state law. But that's irrelevant to this court's inquiry, because as the prior panel in a previous appeal found, the district court doesn't have to find that the Delta Charter School was the original violator. All it had to find was that they violated the consent order. So the issue of whether or not Delta in the history of this case violated the 14th Amendment is irrelevant to any analysis that this court should make. Now, I'll also say that I did also want to touch on one argument that we've made in our brief too, because with my time I do see, we also think that Delta should be stopped from making this argument. They have taken the position below to enter into these consent orders to resolve issues in this case. Originally in 2013 and then again in 2018, they entered into the enrollment process consent order with the district court that set out this one-to-one kindergarten enrollment. They also convinced the district court to accept that position because the district court adopted the consent orders. And under estoppel, they should be stopped from making these arguments, Your Honor. And if there are no further questions, I'd yield back the remainder of my time.
Thank you. All right, we'll hear from Mr. Lee for the United States. Welcome.
Good afternoon, Your Honors. Jason Lee for the United States. This court should affirm the district court's ruling on judicial estoppel grounds, but I would like to first begin with responding to some of the issues that have been raised by the panel so far regarding Rule 60B and Rule 54B. First, as Judge Willett, as you noted, really the only question before the court is whether or not Rule 60B applies. Because if Rule 60B applies, this court must affirm. Delta has not offered any argument for why the district court abused its discretion under Rule 60b-5. So if this court concludes it applies, it must affirm. Now we know Rule 60b-5 applies, and that's because of this court's prior decision in Delta's prior appeal. Both the majority opinion and Judge Ho's concurrence uses the same language. It suggests that on remand, Delta may move to modify the consent order, all but telling the parties you need to move under Rule 60b-5. And in fact, Delta knew about Rule 60b-5. In its untimely motion in 2017, Delta not only cited Rule 60b-5, but Rule 60b-2, 3, 4, and 6. So this is a circumstance where clearly the motion was made under Rule 60b-5, and indeed one of the cases that's cited in Delta's brief, the Moore case, M-O-O-R-E, specifically notes that in determining whether or not you're looking at a modification motion, you look at the substance, and here the substance is We just want to remove these particular enrollment policies. It was a modification motion.
Well, everybody knows that aside from the merits, there's on appeal, our hands are basically tied by forfeiture or waiver. Is that not the case here?
It's effectively the same thing, Your Honor. I would put it this way. There's no dispute that the district court did not abuse its discretion. There's no suggestion of any error or misapprehension or misapplication of law. Now, regarding Rule 54B,
I think as you led off, it's your view, Mr. Blanchard, I'm sure would agree, that if we decide that Delta forfeited any argument that the district court abused its discretion in denying the 60B motion, then we need not kind of deal with judicial estoppel or...
That's correct, Your Honor. Regarding your question about Rule 54B, it has been waived. As the panel discussed, it was not raised in the initial motion before the district court. It has not been raised or adequately argued on appeal. Judge Willett, as you noted, there's case law in this court noting that inadequate argument abandons the issue. You yourself noted that proposition in your Colonial Oaks case 2 years ago. Judge Douglas, you asked about whether or not Delta's current compliance could be construed as a change in fact. That proposition would be barred under this court's decision in Frazier, F-R-A-Z-A-R. It's also barred under Judge Wiener, your opinion in Chisholm, which issued just 2 weeks ago. I want to note one more thing, which is that Delta disavows any reliance on the Students for Fair Admissions versus Harvard case, does not rely on that as a change in law. That's entirely reasonable, given that this court gave Delta the opportunity to raise that argument. It said, you guys can provide supplemental briefing on the case if you want. Delta provided supplemental briefing and never suggested that Students for Fair Admission is a change in law. In fact, if you look at its table of authorities, Rule 60B is not cited anywhere. Putting those arguments aside, I would like to touch on judicial estoppel because I think that makes clear another basis for affirming the district court. Now, what you have here is a party that has, in reality, been playing fast and loose with the courts. And I think Delta's conduct leading up to its prior appeal in this case before this court makes that clear. Now, even back in 2018, when Delta was arguing in this court, talking with Judge Ho about parents involved, simultaneously, it was in the district court crafting the 2018 consent order and negotiating it with the parties. In fact, it asked the court jointly to enter the 2018 consent order just 1 month after oral argument before this court. And the 2018 consent order contains more specific, more explicit race-based remedies than the 2013 consent order. That is a clear endorsement and understanding that race-conscious remedies are permissible in the context here. And if there was ever a case where judicial estoppel was appropriate because a party is playing fast and loose with the courts, it would be this case. And indeed, Delta benefited from that 2018 consent order. It got to set the terms under which it could continue operating its charter school. And in exchange for Delta's adherence to those terms, the United States waived further litigation on the issue. The school district waived further litigation on the issue. And now 4 to 5 years later, Delta is back in this court saying, those terms that I helped write, they've actually been unconstitutional all along. Now, the one thing I'll say is, I think there's a reason why all of these rules, Rule 60B, Rule 54B, judicial estoppel, they kind of all point in the same direction here. And that's because they reflect bedrock principles of finality. And under those bedrock principles of finality, as you noted, Judge Willett, there's really no need to address Delta's arguments under parents involved, whether you construe it as waiver, forfeiture, or abandonment. I'm happy to talk about any of those issues, but if not, the one thing I'll leave this court with is the point that the 2018 consent order has really been working. It's been successful. It has ensured that Delta has refrained from impeding and frustrating the school district's efforts to eliminate the vestiges of a dual school system. And at the same time, Judge Drell, the district judge here, has been actively engaged with the parties to try and move the Concordia Parish School District towards unitary status. Just 2 months ago, he personally took a site visit to 7 of the school district's 11 schools. He has previously requested briefing on the issue of unitary status. 2 weeks from today, he's going to be meeting with the Concordia Parish School Board. So I think there's every reason to believe that this district judge will keep that process moving. And now that we have this 2018 consent order that's making sure that Delta's not going to interfere with that process by siphoning off non-black students, it's entirely permissible to just let this play out. So unless there are any other questions from this court should affirm the district court's ruling.
Mr. Lee, thank you. Mr. Hooks, you're back with 5 minutes.
Thank you, Your Honor. Delta has not been playing fast and loose with the court, Your Honor. In fact, Delta Charter School is the only entity operating a school in Concordia Parish that has never discriminated on the basis of race. In fact, to date, Delta Charter School has never refused admission to an African American student. Delta has been working very hard to comply with the court's orders, and the court has said as much. What we have said, however, is, and the court's orders bear this out, we're the ones who said, Your Honor, at some point there must be an end to the desegregation case. We know it can't last forever. Although, as I mentioned before, the parish made the representation in 2012 that the school board represents that it fully intends to pursue a declaration of unitary status. 10 years later, it has not filed such a motion. In 2015, as the record indicates, the district court said that it expects the parties to proceed actively in evaluating this case for movement toward unitary status. That, on the part of Concordia Parish, was not done. In 2021, the parties were ordered to file briefs in the case on the subject of unitary status, and that's when the so-called exit strategy briefs were put forward before the district court at the urging of Delta Charter School. And then, most extraordinarily, in December of 2022, the district court, finally frustrated with Concordia Parish's inactivity in the case, said, this order serves to put Concordia on notice. The school system must act more urgently to fulfill its desegregation obligations and free itself from the court's supervision. In doing so, the money spent litigating this case can finally be rerouted to serving the needs of those who are most important here, the student. The court went on to say, in its landmark desegregation decisions, the Supreme Court meant for its mandates to the courts to be active and not passive. But after 57 years of litigation, Concordia has filed less than 20 annual reports documenting its compliance or lack thereof with its desegregation obligations. These reports evince, sadly, Concordia's meager attempts at shedding the vestiges of its dual school system and finally being declared unitary by this court. That must change. And even, I'll remind the court, when Delta opened at 15% black, it was more racially diverse than the schools in which 51% of all Concordia students attended. And even at this late stage in 2023, although neither the Department of Justice nor Concordia Parish believes there is any problem with regard to its student assignment plan, the Monterey schools are virtually one-race schools, and the Faraday schools are virtually one-race schools. Concordia has been a racially diverse school from the outset and continues to be. In fact, it's the most racially diverse school in Concordia Parish operating anywhere there. And it's the only one with a superimposed court-ordered racial balancing system that is designed and ordered to mimic the racial composition of the entire
Mr. Hooks,
parish.
your friends on the other side both underscored the waiver argument. So you've got a minute and a half left. What can you offer to kind of allay any concerns that I or others might have about waiver?
Well, what I would say about it is if one looks back at the 2013 order, one sees that the order itself was described by the district court as offering racial targets, not racial guarantees in some way. there was an honest disagreement about what the 2013 order required of Delta Charter School. And as time evolved, and we ended up in 2017, the district court showed absolutely no interest in learning anything about what was happening with regard to any operations on the parish side of the equation. We marched forward with the 2018 negotiation, or the then council did, because the district court had ordered Delta to design and implement a race-based admissions program. That was something specifically ordered by the district court. So that was put in place as a requirement by the district court, and Delta operated under that requirement, in part because the continued litigation expenses of continuing to litigate with the Concordia Parish School Board and with the Department of Justice proved almost catastrophic for the charter school at that point in time. So that was part of the problem and part of the reason that Delta stayed the course and said, well, we've been ordered to do this. We're going to put the plan in place, and we're going to abide by it, which is exactly what they did.
You have a little 10-second wrap-up. Your time's expired. You want to put a bow on it?
Your Honor, one of the things that we see is that there has been an active movement on the part of the district court, on the part of the Department of Justice, on the part of Concordia Parish, to stay away from an examination of what is a very weighty issue that ought to concern the district court greatly, and that is the constitutionality of the admission scheme. We have briefed that, I think, very well in our brief in terms of looking at the reason that the remedy here is not narrowly tailored. The remedies the district court ordered in 2017 and that exist as imposed against Delta in the case do not match up with, in any logical or any consistent way, with actual constitutional violations, certainly not on the part of Delta, but certainly not on the part of Concordia Parish either. And for that reason, they're unconstitutional.
Folks, I think we have your argument. Thank you. We appreciate it. The case is submitted. And we'll give y'all a chance to gather your